include your coaching centers or might not include your school. So when we talk about academia, we generally refer to higher education institutions, which generally include your colleges and your universities. And when we talk about legal academia, we are referring to institutions which are imparting legal education, right? So that's the meaning of academia. So then let's try and understand what sort of job profiles we are looking at when we talk about importance of research in academia. So basically, we're looking at people who are teaching at these institutions, your professors, your associate professors, your assistant professors, your lecturers, your PhD researchers, or any other researchers who are associated with your institutions. So basically, we're looking at their work and we are talking about why for these individuals, it's very, very important to do research. Okay. Now, one important stakeholder in this entire understanding of academia is student, right? So most of the institutions nowadays, they focus a lot on research. They train their students to do research. For example, at IFIM Law School, we have something called research incubation, where the faculty members, we take students and then we guide them to do research, right? So these are the people who are related to academia, and their research then becomes very, very important. Okay. Now let's try and understand what do we mean when we say research and what are the components of research. Now, research here for our purposes for today's discussion would include, for example, writing a textbook, or include writing a standalone book on a very niche topic, or include writing a research paper, or include writing, let's say, a blog post, or include writing opinion pieces in leading newspapers and journals. So these are the avenues where you can find or you can produce your output, right? Now, I think the audience might be well aware of what is the meaning of research. I'm not going into the detail of what is the meaning of research. If you have any doubts, you can ask in the chat box. So these are the components of research, right? You pick up a topic, you work on it, and then you present your ideas at the avenues which I just discussed. Now then comes the most important question for our discussion for the day is, what is the importance of research in academia? Why should somebody who has been given the task of teaching a subject or teaching a course on, let's say, constitutional law, should do research, right? The person or the title of the post says professor or lecturer for that matter. So if I'm a professor, if I'm a lecturer, my task should be that I should go into a class and talk to my students about meaning of a particular topic. Why should I, as a professor, then also be bothered about researching? If I'm very much interested in research, I should rather go and join a research institution, a think tank, right? Why get into academia? Why become a professor and still talk about importance of research? Now, this is where I then list out certain reasons these reasons will highlight what is the importance of research. Okay. Now, the first important reason for doing research in academia is to learn lessons from other jurisdiction. Okay. Now, what is the meaning of this? What is the meaning of learning lessons from other jurisdiction? And for the purposes of today's discussion, considering the audience which we have, I picked up a very common topic from law, that is constitution law, because I believe most of us have a basic understanding of what is the meaning of our constitution. Even if you're not from law field, we have some sort of understanding of what is the importance and meaning of Indian constitution. At some point of time, we have seen our constitution, we have seen the preamble of our constitution, or have heard about the constitution. So rather than picking up any niche area of law, I've taken up constitution for the understanding of our topic. So the first important reason for doing research in academia is to learn lessons from other jurisdiction. Okay. Now, if you want to learn lessons from other jurisdiction, the first question which should come is, why do you need to learn lessons from other jurisdiction? My own jurisdiction is enough. I have my own society. I take lessons from my own society. Why do I need to learn lessons from other jurisdiction? Okay. Now, for this, we go to the very beginning of this nation called India, and we go to the very beginning of drafting of the Indian Constitution, right? And this is where we then shift to another important topic, which is an example of learning lessons from other jurisdiction, which is about our Article 21 of the Indian Constitution, which talks about due process. Now, there is a very fascinating story behind Article 21 of the Indian Constitution, that the drafter of the Indian Constitution, Dr. B.N. Rao, when he was on a visit to United States of America, he happened to meet the then Justice Felix Frankfurter of the US Supreme Court. And Justice Frankfurter advised B.N. Rao, knowing the fact that the Indian Constituent Assembly is still drafting the Indian Constitution, advised him that you should not include procedure established by law, or you should not include due process of law, something of that sort. If you read Article 21 of the Indian Constitution, currently it says, no one shall be deprived of his life or liberty except according to procedure established by law. So the term which is used is procedure established by law. Okay. So it was Felix Frankfurter, who was a judge of the US Supreme Court, who advised B.N. Rao that the Indian Constitution, which was being drafted at that point of time, should not use the word due process of law. Rather, it should use the term procedure established by law, right? And that's why when B.N. Rao came back to India, he passed on this advice to the Constituent Assembly. And if you see the current Indian Constitution, the Article 21 does not use the word due process of law, but rather it says procedure established by law. Now, due process of law is a term which was there in the American Constitution, which was added to the Fourth Amendment to the American Constitution. And Felix Frankfurter had realized by that time that it's a very difficult proposition to have in your Constitution, and that's why he advised B.N. Rao that you should not have this term, and rather you should have procedure established by law. Now, this has served us well. This advice has served us well because B.N. Rao took this advice and passed on to our Constituent Assembly. And now in our Constituent Assembly, in our Constitution, Article 21, when we see that the term which is used is not due process of law, but a procedure established by law. Now, what you see on your screen is a recent book which is written on Article 21, specifically on the term due process and procedure established by law. So the book is titled, as you can see, Liberty After Freedom. Now, this is a perfect example of the importance of doing research. Now, this book, now I told you the incident is from 1947-48. Okay. Now we have a book which was published, if I'm not wrong, in 2021 on the same Article 21, which was drafted almost 75 years ago. Now, one would then say that what is the need on researching on 2, 4, 5 different words which appear in Article 21 of the Indian Constitution, right? But this goes on to signify the importance of doing research, because this term which appears in the Indian Constitution has been hotly debated. What is the meaning of this term? If you look at the Constituent Assembly debate, there are a lot of debates which happened, particularly on this term, that what is the meaning of due process and what is the meaning of procedure established by law. Okay, so then it becomes important to do research and understand how the courts have historically interpreted. Now, in the context of this particular topic which we're discussing, that is due process versus procedure established by law, another judgment which is important is Maneka Gandhi versus Union of India, where going against the expressed wordings of Article 21, the Supreme Court said that the term which appears in the Constitution, procedure established by law, is equivalent to due process of law, which of course, as per many authors, is a wrong interpretation of Article 21, because these are the two terms, due process of law and procedure established by law. And the Indian Constitution drafters went in favor of procedure established by law. But in Maneka Gandhi, the Supreme Court said that procedure established by law is equivalent to due process of law, which is wrong as per many authors. Why? Because the Constituent Assembly also had these two options and decided expressly not to go for due process, but to go for procedure established by law. So what we need is, in the context of importance of research in academia, is lessons learned from other jurisdictions. What is it that we can learn from other jurisdictions? By that time, in 1947, the American Constitution was more than, if I'm not wrong, 150, 170 years old, right? So it's very important to learn lessons from other jurisdictions. That's point number one for the importance of doing research in academia. Now, for example, I present multiple books here. And all of these, as I said before, most of these are related to Indian Constitution. Okay, so if you see here, a People's Constitution, which is about the first few amendments made in the Indian Constitution. And this book was published in 2019 or 2020. Okay, now one would say that what is the need of writing about the First Amendment or the Second Amendment or the Third Amendment more than 70 years after the amendments were made? Okay, now second book, if you see on the right side, it says India's founding moment. Now this goes to the very founding moment of India, when India was found as a country. Now, this Professor Madhav Khosla, currently, if I'm not wrong, is working at Yale. is talking about importance of that founding moment when India was founded as a country. Okay. Now, subsequently, you can see this book on the left side says Ambedkar's preamble. Now, this entire book is just about the first page of the Indian Constitution, which is the preamble of the Indian Constitution. And secondly, on the right side, which you see 16 stormy days. Now, the 16 stormy days is entire book is about the first amendment made to the Indian Constitution. Okay, and all of these books which I'm showing have been produced in the last 3 to 4 years. Okay, again, this is one exception where you say Granville Austin's The Indian Constitution, Cornerstone of a Nation. This is more or less a commentary on the entire Indian constitutions and its formation, which is a very ancient book. And finally, the book, The Great Repression, which is about the story of one section of Indian Penal Code, not about the entire Indian Penal Code, just one section of Indian Penal Code, which is about sedition. So the point which I'm trying to make is, for an academician, it is very important to continue doing research because most of the laws, they keep changing. Okay. And this then takes me to the second point, which is relationship between law and society. So the first point, if you remember, let's revise it just quickly. The first point which we discussed was why it is important to do research in academia. It's important to do research in academia because we need to learn lessons from other jurisdictions. Now, the second important reason for doing research in academia is the relationship between law and society. Now, here we have two examples, that is section 377, which pertains to homosexuality, and section 497 of IPC, which again pertains to adultery. Now, why again these two examples are relevant for our discussion? Because it proves our point that there is a very intrinsic relationship between law and society. And because society keeps on evolving, because society keeps on changing, law has to keep pace with that change. And that is the reason, this is where the role of an academician comes into picture. So when you say that, for example, when IPC was drafted, 19th century, second half of 19th century. Now, right now we are in 21st century. Now, how and to what extent society has changed from the second half of 19th century to 21st century. The law will have to take into account homosexuality or consensual sexual relationship between two people of same gender was criminalized way back in the second half of 19th century. But right now, the society has evolved to the extent that the society has started accepting this sort of relationship. Hence, this section 377, to the extent that it criminalizes homosexual relationship, has been held to be unconstitutional. Now, as a researcher, here comes our role to understand how the society is developing, to understand to what extent the society has developed. Now, again, as a researcher who, let's say, is working on gender issues, I would still be interested in working more on 377. Why? Because same-sex marriages are still not allowed in India. Okay, so we understand that yes, society might have developed to an extent where it is accepting homosexual relationship, but it's still not accepting homosexual marriages. So that's still a point of research, which as an academician, I would continue doing. Second is about 497. Now, 497 again is from IPC. Okay, now again, going back to 19th century, right? Now, here again, 497, which is about adultery. There is a relationship between law and society. The context in which the societal context in which this particular law was drafted. And this is where I would then quote these two paragraphs from the judgment, which was on homosexuality, Joseph Shen versus Union of India. If you look at this quotation taken from the part of the judgment written by Justice Chandrachud, who is currently the Chief Justice of India, he says the law on adultery conceived in Victorian morality considers a married woman the possession of her husband, a passive entity bereft of agency to determine her course of life. The provision seeks to only redress perceived harm caused to the husband. This notion is grounded in stereotypes about permissible action in a marriage and the passivity of women. Now, this paragraph highlights the context in which the law was drafted. What was the context? The context was that we were a British colony, and the British colonizers were drafting this law for us. So the Indian Penal Code, which we have, is more or less present in more than 30 countries in similar forms, not exactly the same, but in similar forms. And it was drafted in the era of Queen Victoria. So there is some sense of Victorian morality which is attached to it. What is the role of a woman? What is the role of a wife in a relationship? So if you look at this particular section, it gives no agency to the wife in a marriage setup, right? So this is one part of the judgment written by Justice Chandrachud. Now, in the second part of the judgment, Justice Indu Malhotra again comments on the same thing, where she says that this definition of adultery emanated from the historical context of Victorian morality, where a woman considered to be the property of her husband, and the offense was committed only by the adulterous man. The adulterous woman could not be proceeded against as an abettor, even though the relationship was consensual. So if you look at section 497, it only punishes husbands for commission of adultery. If a wife is committing adultery, there is no punishment. So this is again taken from the Victorian understanding of how a wife is supposed to be in a marriage. Now, this again reflects the context of the society and its relationship with law. And this is where, again, the importance of doing research in academia comes into picture. Now, then moving on to the third reason for importance of doing research in academia, it's contemporary development, where you want to understand what are the best practices available in a particular branch of law, and then maybe adopt those practices for your country. So, for example, human rights. Now, for example, most of the countries nowadays have abolished death penalty as a valid form of punishment. But India continues to have death penalty as a valid form of punishment. So here then comes the question that why, as an academician, it's our duty to understand why certain countries have abolished death penalty. Has that abolition been beneficial to their country or not? And then maybe draw some parallels, draw some lessons from that exercise from a foreign country, and see if we can apply those same lessons to our country. Second, for example, in the case of international investment law, what are the best practices available in other countries? What are they doing to attract more investment in their country? And then maybe have those same provisions for your own country. This is the role of an academician. As an academician, I want to see which country is attracting more investment. If China has historically, for probably last half a century, has been a great attraction point for investors, what is it about China that people are investing? What are the laws in place which protect rights of investors, which protect rights of domestic players, and maybe then draw some lesson and make similar laws for our country. Okay. And then comes the final 2 point about importance of doing research, which is about, first point is about revision in syllabus. Now, for example, as an academician, I need to know what are the ongoing developments in law. Now, for example, if I'm totally cut off from any development in law, I just pick up one textbook, let's say it was written in 1980, and I'm teaching day in and day out from that textbook only. That textbook, if it is not revised, was written in 1980. A lot of laws have changed since 1980. So the education which I'm imparting to my students does not take into account the recent development. For example, somebody who's teaching from, let's say, a textbook written in 2010 on IPC does not know about the two decisions which we just talked about regarding section 377 and regarding section 497. So the students who are being taught by that particular professor, of course, will not know about 377 and 497. Okay. So it again leads to some change in the syllabus. You need to keep yourself updated with whatever is happening in academia and accordingly change your syllabus or keep updating your syllabus. And then final point is about revision in pedagogy. This again is important through research. For example, there is a book published by Harvard University Press, if I'm not wrong, which is titled "What Best Law Professors Do." Now, if I am into this profession of teaching, I want to improve myself as a teacher. So I want to learn lessons from other professors. Now, this book, for example, tells me what are the best practices which are being followed by other professors in other colleges, and then do some research about what is the importance of teaching, how I can improve on my teaching, and then accordingly imbibe those learnings in my own pedagogy. That will again be beneficial for my students. So these, I believe, are the, you cannot give a number to what are the reasons of importance of doing research, but I believe for this short interaction, these are the 5 important reasons for doing research in academia. We'll quickly revise, which was the first one was learning lessons from other jurisdiction. Second one is about relationship between law and society. If society is developing, law also needs to keep pace with it. Third is about contemporary development, where we learn about the best practices in other countries and then try to imbibe those practices in our country. And then finally about revision and syllabus, and revision is pedagogy. That's it. If there are any questions, I'm happy to take those questions. All right. So if there are no questions, in that case, we'll wind up the session.